This presentation provides a quick summary of California's autonomous vehicle regulations. It does not constitute legal advice or legal advertising. Please consult your own lawyer as to the interpretation of these regulations and how they may apply to your company. In 2012, California's legislature passed a law directing the Department of Motor Vehicles to issue regulations governing autonomous vehicles. The DMV has done so in two phases. First, in 2014, regulations were passed that provided for testing but not deployment of autonomous vehicles. While the industry at that time wanted to be able to test vehicles without a human driver behind the wheel, that was not allowed, and the regulations that were in place from 2014 until 2018 required a human driver behind the wheel during testing. In April of 2018, new regulations were passed, and these regulations amended the 2014 regulations for testing and also added a new section governing deployment of autonomous vehicles. The 2018 regulations did not include any provision for testing or deployment for certain types of vehicles, including motorcycles, trailers, and commercial trucks with a gross vehicle weight of 10,001 or more pounds. But the DMV has indicated it will start a special rulemaking process for these other vehicles, including commercial trucks, and a public workshop to gather and discuss input on the development of these regulations is now set for October 2018. Let's go through the current 2018 autonomous vehicle regulations in California. First, the definition of autonomous vehicles has been set at a level that only includes fully autonomous vehicles and not technologies that provide for driver assistance. The SAE has certain levels of vehicles, I think it's 0 through 5, that you can look up if you're not familiar with. But California decided that autonomous vehicles would only be SAE level 3 through 5 vehicles, which can fully drive by themselves. This rule avoids retroactive application of the rules to cars that are already deployed on the road with SAE level 2 technology. So level 2 technology includes driver assistance technology that's found in Tesla Autopilot or GM Super Cruise. California didn't want these rules to apply to cars that were already driving around on the road. So autonomous vehicles are limited to levels 3 through 5. California, through these regulations, is not trying to regulate motor vehicle safety standards. So instead, California is relying on the federal rules in this area. So a manufacturer must certify that the autonomous vehicles being tested or used in California meet the current federal motor vehicle safety standards, or provide evidence that the vehicle has an approved exemption from NHTSA or by federal law. So if a vehicle does not have a steering wheel or other provisions that are usually found for human drivers, such as a signal or mirrors, that vehicle will need to get an exemption from NHTSA in order to be tested on the roads in California. The federal government, through NHTSA, has also recommended that autonomous vehicle manufacturers complete what's called a voluntary safety self-assessment. Completion of this self-assessment is entirely voluntary, according to NHTSA, and the California rules do not require it. So California is not making mandatory compliance with a provision that NHTSA has decided is voluntary. Though if companies do publish a voluntary safety self-assessment, that document should be submitted to the DMV. California also has made its regulations consistent with the way that NHTSA has governed safety for vehicles for many years. California does not require any kind of government pre-market approval or third-party testing before a vehicle qualifies for permits in California. The DMV considered this option and concluded that it was unable to formulate pass-fail criteria that would be used for all testers. As a result, manufacturers will need to make certifications to the DMV, as we'll discuss, in order to obtain various permits. But the DMV itself is not going to test vehicles before they're allowed on the road. And this is consistent with how NHTSA has governed all automotive safety for many, many decades. As I mentioned, the 2014 regulations in California required a human driver in the test vehicle. The 2018 regulations do not require a person in the test vehicle at all, and the DMV made this provision noting that it felt the capabilities of autonomous technology have proceeded to a point where manufacturers do have systems available that are capable of operating without a driver. So we'll see going forward that there are two kinds of permits that will be available. One for testing with a human driver in the vehicle, as has been permitted under the 2014 regulations, and now a new permit for companies that wish to test without a driver in the vehicle. So let's go through the testing provisions. They're found in Article 3.7 of the regulations. So as I mentioned, there is still a testing permit available for testing an autonomous vehicle with a human driver. The driver has to be in the car and ready to take over driving at any time. And there are certain specified qualifications for the test driver and training that must be completed. All of the permits in California require companies to meet certain financial responsibility, insurance, and identification requirements. In addition, in order to test any vehicle on public roads, the manufacturer must have tested the vehicle under controlled conditions that simulate as closely as practicable each operational design domain that it plans to test. So the manufacturer must have reasonably determined that it is safe to operate the vehicles in each operational design domain. So if a company is testing a vehicle with a human driver and plans to do that testing at night or in the rain or on freeways, the manufacturer must have reasonably determined that it's safe to operate the vehicles under each of those conditions. If a manufacturer wants to obtain a permit to test vehicles without a human driver in the car, the manufacturer must certify that the autonomous vehicles are capable of operating without a driver and that the technology itself meets the description of an SAE level 4 or 5 vehicle. The vehicle must also be monitored by what the DMV is calling a remote operator, who engages and monitors the autonomous technology and is able to communicate with any occupants of the vehicle using a communications link. The manufacturer must certify it will continuously monitor the status of the vehicle and describe how it will monitor the link and all of the test vehicles in its fleet. In addition, in order to obtain a permit to test without a driver, the manufacturer must certify that it has notified the local authorities, so cities and counties, where testing will occur, and it must provide certain specified information to the authorities where and when the testing will occur. The manufacturer does not need to obtain permission from the local authorities, and there's no provision for the local authorities to prevent the testing, but the notification must occur. In addition, the manufacturer must notify the DMV of the operational design domain for each vehicle and then update if that changes. Manufacturers must also submit a law enforcement plan with 8 specified components explaining how the car will interact with law enforcement and first responders. For manufacturers that obtain a testing permit to test autonomous vehicles either with a driver in the car or without a driver, manufacturers must complete certain reporting. First, if there are any collisions, those must be reported within 10 days if there's any property damage, injury, or death. And in addition, companies must report disengagements during testing. And disengagements are defined as a deactivation of the autonomous mode when a failure of the autonomous technology is detected, or when the safe operation of the vehicle requires that the driver disengage the autonomous mode, or where the vehicle does not have a driver, when the safety of the vehicle, the occupants, or the public requires deactivation of autonomous mode. The 2018 regulations provide that manufacturers must submit annual reports summarizing disengagements. These will report the total number of miles each autonomous vehicle was tested, whether the test vehicle can operate without a driver, and the circumstances or testing conditions at the time of the disengagements, such as the type of roadway or location, whether it was operating without a driver, and certain facts such as weather, traffic, construction, or accidents, and the party that initiated the disengagement. Before we move on to the section governing deployment of autonomous vehicles, I'll just note that with respect to the testing permits, while there are more than 50 companies that have been testing on public roads in California with a driver in the vehicle, the new permits for driving without a driver in the vehicle for testing purposes have not been issued yet. So I don't believe there are any permits for testing without a driver in the vehicle that have been issued so far by the DMV, but I'm sure that will change going forward. Moving on to deployment, similarly, these provisions are in place, but no permits have yet been issued for deployment. So let's talk about what that is. Deployment is considered the operation of an autonomous vehicle on public roads by members of the public who are not the employees, contractors, or designees of a manufacturer or other testing entity. So deployment occurs when you put the vehicle on the road with someone other than a person controlled by the testing entity. So deployment includes selling a car, leasing a car, or otherwise making vehicles available outside a testing program. Offering transportation services to members of the public where a fee is charged, such as in a rideshare context like Uber or Lyft, also constitutes deployment. So if any of the companies that are developing autonomous vehicles want to offer an autonomous ride service to the public, as soon as they want to charge a fee, that's when it's considered deployment. So they'll need to have a special deployment permit in order to do that. A permit for deployment, similar to a permit for testing, requires the payment of certain fees and licenses and meeting the financial responsibility requirements, which is $5 million. The manufacturer will also have to certify the vehicles comply with the federal motor vehicle safety standards or have received an exemption. The manufacturer will have to certify that it has conducted test and validation methods and is satisfied the vehicles are safe for deployment on public roads in California. There are no specifications, again, issued by the state of California regarding safety or what constitutes vehicles being, safe enough for deployment. This is a standard that will either be defined ultimately by the federal government, or today, where there are no regulations at the federal level, will be incumbent on manufacturers to make a determination that they feel the vehicles are safe for deployment. In addition, the manufacturer will have to provide a summary of the autonomous vehicle testing in the operational design domain for the vehicle they are seeking to deploy. It will have to describe the locations where the vehicle was tested, the total miles driven, the testing methods used to validate performance, and a description of any collisions. So for each autonomous vehicle that manufacturers are seeking to deploy, they will have to specify the operational design domain and certify that the vehicles are designed to be incapable of operating in autonomous mode in areas outside the disclosed operational design domain. So if the operational design domain consists of a certain geography, let's say downtown San Francisco, then the vehicle will have to be designed to be incapable of operating in autonomous mode in Silicon Valley or other areas outside the downtown San Francisco area. Similarly, if the car is designed only to be driven during the daytime, it will have to be incapable of operating in autonomous mode at nighttime. The manufacturer also will have to identify commonly occurring or restricted conditions like snow or fog or geofencing where the vehicle is unable to operate reliably, and certify again that the vehicle will be designed to be incapable of operating in autonomous mode when those conditions arise. Or state that there's a mechanism for disengaging autonomous mode and reaching a safe state when that occurs. Manufacturers will have to provide a description for how level 4 and 5 vehicles will achieve a minimal risk condition and safely come to a complete stop when there's an autonomous technology failure. Because deployed vehicles, it's assumed that there will not be a driver in the car. They want to be sure that it can come safely to a stop if there's some sort of failure. A few other requirements for the deployment permit. The manufacturer must certify that the autonomous technology is designed to comply with the California Vehicle Code and any local regulations. So it's going to need to follow the rules of the road and speed limits and stop signs and all of those things. In addition, the manufacturer must certify it will make available updates to location and mapping information used for vehicle location and operation on a continual basis, consistent with changes to the physical environment captured by the maps. So if a road is closed for construction for 3 months, the DMV wants to know that the manufacturer is going to update the autonomous vehicle information so that the vehicle is aware that a road has been closed or something like that. In addition, the manufacturer must also submit a consumer or end user education plan with specified topics. It seems that this is aimed more at autonomous vehicles that are sold to the public, and remains to be seen whether or when that will happen. In addition, with respect to deployment, manufacturers must certify that the vehicle meets appropriate and applicable current industry standards to defend against cyber attacks or intrusions. Again, California is not setting forth any kind of a standard as to what is required with respect to cybersecurity of the vehicles. It's simply noting that if there are appropriate and applicable industry standards, that the vehicle should meet those. Those obviously will change over time and really haven't been developed in any formal way for autonomous vehicles yet. Manufacturers also must certify that driverless vehicles have the required communication link and remote operator and monitoring, and that the vehicles are equipped with a special autonomous technology data recorder, which is defined in the regulations. This is a special data recorder similar to a black box that might be found in airplanes that will record specified information in the event of a crash. Finally, the California rules have an interesting advertising restriction. The rule provides that no manufacturer shall represent in any advertising for the sale or lease of a vehicle that a vehicle is autonomous, unless it meets the definition in these regulations, which, as I mentioned earlier, is SAE level 3 through 5, and a permit under these rules has been obtained. This prescription includes not just the word autonomous, but also use of a term to describe the performance of a vehicle that is known, or by the exercise of reasonable care should be known, would likely induce a reasonably prudent person to believe a vehicle is autonomous. This is aimed clearly at assisted driving technologies that are not fully autonomous and that don't come under the purview of these rules. And the DMV is trying to make sure that people understand when a vehicle is autonomous versus when it just has assisted driving technology. Thanks for watching this presentation. You can also listen to the Smarter Cars podcast for additional information about autonomous vehicles. And on the podcast, we did interview Brian Soublé, the Chief Counsel for the California DMV, and got his interpretation of some of these regulations as well. You can find that on Apple Podcasts or wherever you listen to your podcasts. Thanks for listening.